Good morning, everyone. We're just waiting for people to jump onto that link, and then once they jump on, then we'll kind of kick things off and get things started. Amy, I have to be honest. I did look at the weather so that I can make some conversation, and I saw that it does seem like there's pretty nice weather for the next few days. Out in
Yes,
London.
it's gorgeous. It's looking gorgeous in London this morning. I'm in the city and the sun is shining.
Oh yeah, absolutely looks nice. For anybody that maybe visited the offices or anything like that, I definitely got a little bit of a sneak peek when we were in our video call last time, and it looks gorgeous, like absolutely beautiful windows with the sun kind of coming in, so it's really nice. Yeah.
Yeah, it is. And we've had lots of rain in the UK in the last couple of weeks. So we're hoping for some dry weather going forwards.
Yeah, no, I can imagine. I mean, is it have you kind of seen the weather change at the moment where it's going a bit colder, or I've noticed it's like 20, mid-20s even this
Yeah,
week.
this weekend it's supposed to get up to I think 22 and full sun according to the BBC. So I'm very excited about what the weekend holds.
Funny you say the BBC because that's exactly what I checked in terms of the weather. Glad that
Yeah.
that's the reputable source, so I'm glad I checked the right thing.
Yeah, I'm sure other sources are available, as they say, but yeah.
For anyone joining, don't worry, we haven't kicked off yet. We will start shortly. I'll give it another, half a minute or a minute or so, and then we'll get things started. I can definitely see people jumping onto that link, so we will get things underway soon. But yeah, Amy, so with kind of the week ahead, is there any plans? Have you got anything planned for the nice sunny weather?
Oh, well, my family's a big cricket family, so we're looking forward to lots of cricket this weekend. We've had lots of cancellations of matches in the last couple of weeks because of waterlogged pitches. So yeah, that's what we'll be doing. We'll be on the cricket pitch for Thursday, Saturday, and Sunday, I think.
That's right. I feel like cricket's not one of those, it's not like a soccer or rugby situation where the water can be your friend at times.
No, it's very weather dependent. So it's been a bit of a wet start to the season, unfortunately.
Fair enough. All right, so we'll get things underway, everyone. I know that we're a couple of minutes in. I just wanted to say good morning to everyone. Thank you so much for taking out your time to join us today for our webinar, which is covering employment law updates in the UK. I can say definitely, because I was a part of the last one, that it has been a while since we have done a UK webinar. So a lot has changed in the employment law space. And this is definitely the webinar for you if you want to see what the updates are and what's been happening. And we are so excited to bring these updates and changes to you. Now, my name is Sanam. You must be wondering, who's speaking to me. My name is Sanam. I am the Employment Counsel here at Employment Hero, and I am joined by an amazing employment lawyer. I say amazing because Amy's kind of track record and just the way that she is with clients as well is completely unwavering, and the commitment is unwavering to her clients. And so I'm so excited to introduce Amy Cunningham. Thank you so much for being here. Could we get a little bit of background about you, Amy?
Yeah, thanks so much. It's a pleasure to be here. So yeah, I'm Amy Cunningham. I'm an employment lawyer, and I founded 8 years ago and run a small law firm that focuses solely on providing startups and SMEs with really the full range of employment law advice. So I had about 12 years in a much bigger international firm in the city, but decided that I could deliver the same kind of first class advice at a fraction of the cost. And so set out on my own in 2016, and now we are still a very small team with an office in the city. And yeah, that's me.
Oh, that is wonderful. See, I told you, wealth of knowledge, and on top of that, as somebody that actually, cares about clients in the sense of looking at costings and things being a little bit different than the norm when you go to an employment lawyer, I'm sure. But the reason why I say that it is really good to have Amy here, not only for the presentation component, but because we will obviously have a Q&A segment here. But if there's any questions where you're dealing with any advice that you need or anything like that, Amy's details are here on the screen. I also have included a slide at the end, which you can definitely check out the links, jump on and have a look and reach out to Amy directly if you need anything as well. Now, in terms of a little bit of housekeeping, we have allocated, like I said, time at the end of the webinar for all of your questions, and we'll try to get through as many as we can. And the ones that we don't get through, we will definitely see what we can do as a post-webinar kind of material that we send out. Now, you will see that at the bottom of your Zoom screens, there is a box, and that's where you can type in your questions and definitely send them throughout the webinar. I'd also like to note that today's webinar and session is completely recorded. So please don't frantically write anything down. You will be provided with the slides and the recording. And a key part of this as well is that any of the questions or anything that you have, we will be sending that out afterwards. So definitely make sure that you ask your questions and we'll get to them as much as we can. Now, of course, there is always a bit of a disclaimer. Remember that this is not legal advice, but this is why I say it's great to have Amy. You can absolutely reach out and seek specific advice to any situations that you're dealing with, whether you're an employer or an employee. Now, briefly touching on the agenda, we are going through a few things here and there in terms of the changes this year that we're seeing, things that have already come up, as well as looking at what's ahead and moving forward in the months to come and maybe later on down the track next year. So a lot to definitely cover. And we wanted to kick things off with the kind of holiday changes. You know, Amy, I've heard that there's been a shakeup when it's come to irregular hours and what employers need to be aware of. So what would you say would be the key piece of information that employers need to know and need to be aware of?
Yeah, there's been lots of changes in this area in recent years, and lots of cases as well on things like calculation of holiday pay. The changes that I'm going to focus on talking about today are the ones that came into effect last month, which basically created an entirely new and bespoke holiday pay regime for what are termed irregular hours and part-year workers. That permit basically rolled up holiday pay. So, I mean, let's have a look at this in more detail. This is a change that, as I say, only covers two or one group of people: irregular hours workers, part-year workers. So in terms of irregular hours workers, what we're talking about here is someone whose number of paid hours worked in a pay period is variable, either completely variable or mostly variable. So, for example, they might be paid weekly and work a different number of hours each week, and their contract states that their hours will vary. So obviously what we're talking about here are people on 0 hours contracts, casual contracts and bank contracts. If their hours are fixed under their employment contract, they won't be an irregular hours worker, and these changes won't apply to them. The other group, as I said, is part-year workers, and someone's a part-year worker if their contract says that they're required to work only for part of a year, and if it says that there are periods of at least a week when they're not required to work and they're not paid for, but that contract is in place all year round. So what we're thinking about here, for example, is a seasonal worker on a farm or in the hospitality industry where they only work and get paid during certain months or weeks of the year. And the contract says that there are some weeks when they won't have to work and they won't get paid. So that person is a part-year worker. So other categories of people are not affected by this new law. And what the new law says is that for holiday years that begin on or after the 1st of April, there's a new method of holiday accrual, so build up of holiday, a new method of calculating that. And under the new rules, it's part-year workers and irregular hour workers will accrue holiday at 12.07% of the hours they work in a pay period on the last day of the pay period. So to give you an example, and this is actually taken out of the ACAS guidance, which is really worth a read, really helpful guidance there. If you've got an irregular hours worker who's paid monthly and their leave year starts on the 1st of April, and let's say they work 70 hours in the month of June, then their holiday entitlement for June will be 12.07% of 70 hours, which is 8 hours after the rules on rounding up and down have been applied. So that is the method of accrual of holiday for these types of workers. The other interesting change here is that we've got a new concept of rolled up holiday pay. So previously, rolled up holiday pay was not allowed, but now the working time regulations have been amended to specifically allow it. And rolled up holiday pay is when an employer spreads holiday pay over the year by adding an amount on top of someone's normal pay, rather than paying them for their holiday when they take it. And this is an option. So employers can choose to use rolled up holiday pay if they wish to, but they don't have to. And if they do choose to use rolled up holiday pay, then again, it'll be calculated at a rate of 12.07% of the worker's total pay in a pay period. It will be paid at the same time as the worker gets paid for the work they have done in that pay period. And it will be shown as a separate payment on the worker's pay slip. So to give you another example, Sanam, if you've got an irregular hours worker who earns in the month of June £1,000, then in addition to that £1,000, they will receive £120.70 of rolled up holiday pay in addition to that basic pay, which has to be itemised as a separate line on the pay slip. But if, for example, in the following month, they work for 2 weeks and they take 2 weeks holiday, then let's say they earn £500 for those 2 weeks that they work, they will also receive £60.35 of rolled up holiday pay based on that calculation we just looked at. And they will then have 2 weeks holiday, but they will not be paid for it because they've received rolled up holiday pay throughout the year. In terms of what employers should do, you will obviously, during the course of the next few months, probably, depending on when your holiday year starts, you will need to review your approach to holiday pay, looking at for irregular hours and part-year workers, looking at the new system and deciding whether to move to rolled up holiday pay or not. And if you do, then there's obviously going to be updates that need to be made to employment contracts and the staff handbooks, and also making sure your payroll team are aligned with everything. Yeah, so that's a summary of how the law on holiday pay is changing for these specific groups of workers. And as I say, when that comes into effect will depend on what your holiday year is. So it may be immediate or it may not happen until January, and you might have a bit of a runway to get ready for it.
And just out of curiosity as well, Amy, with the part-year workers, are those people that might be project-based workers or doing maybe more fixed-term employment for a set period?
Yeah, it could be any of those types of people, but we're thinking particularly, as I said in the example I used, about people who might be seasonal workers. So yeah.
Okay, perfect. And so just for everybody, you know, again, policy is really important. Update your documents. And I think firstly, like what Amy said, figure out if this is, you know, if you want to roll up the holiday pay, and if that's what you want to do, then speaking to your payroll teams will make a huge difference in terms of making sure you're compliant and you've got it right. So on the topic of changes, I see that there's one area, Amy, that has changed, you know, interestingly. And let's say that I, as an employer, have a carer's leave policy in place. I've heard that there's some changes that are coming up or that have come up around that. What do I need to do to stay compliant, to make sure that my policy is compliant and that I'm doing right by my employees?
Yeah, so carer's leave is an entirely new form of leave that's been introduced from the 6th of April. And it's basically a new type of leave that gives employees, but not workers, a day one right to a week's unpaid leave to care for a dependent with a long-term care need. So this is something that previously wasn't a type of leave in UK law. We have things like time off for dependents, which is more emergency time off to deal with perhaps childcare emergencies or something. Obviously, we have family leave and parental leave, but this is an entirely new type of leave. This leave basically gives, as I say, employees a right from day one of their employment, and it applies to people who have a dependent. The definition of dependent mirrors the definition used in other parts of the law, for example, in the right to time off for dependents. So it would include a spouse, a partner, child, parent, person who lives in the same household, and who relies on an employee for their care. And that person has a long-term care need. So it could be, and I'm looking at the definition here, an illness or injury, whether physical or mental, that requires or might require care for more than 3 months. It could be a disability under the Equality Act, or it could be an issue related to old age. So this new law is intended to allow an individual to provide or arrange care for a dependent with a long-term care need. If it's a short-term care need, other types of leave are still more appropriate. So, as I said, something like time off for dependents, which is another legal right. So this act gives a week's unpaid leave every 12 months. And the leave can be taken flexibly, either as full days or as half days or as one block of a week every 12 months. The employer can't turn down a request for leave, but if it's going to cause disruption to the business, then an employer can ask for the leave to be postponed. And then the other thing to note about this is that it's a maximum of 1 week, regardless of how many dependents the employee has. So that's an important point. And then I think the final thing to say is what's not yet clear is how employers will approach the question of pay, because the right is to unpaid leave, but clearly a lot of employers are probably going to enhance the pay and potentially pay employees full pay for that week. So that's going to be a decision for employers to make. And then, yeah, as I've said on the slide here, in terms of the actions for employers, we are going to have to think about creating a new policy if we don't have one already. Most employers wouldn't have a carers leave policy, but if you do, then obviously it may not already reflect the requirements of the new legislation. There might also need to be a kind of self-certification form for employees to complete, declaring that they meet the definition of a carer and will be using the leave in the capacity that it's intended for. You might need to introduce a new system of record keeping to track the number of days that people are taking and ensure they're not going over that week of leave. And it will also be important to inform people managers of this new right. And also the fact that any kind of dismissal or detriment connected to that leave will be automatically unfair, like other forms of family leave. Yeah, and then I think the only other thing, as I flagged, is there is still other types of leave available for people. So you've got time off for dependents, which is that kind of reasonable amount of time off to deal with an emergency involving a dependent. And then also it doesn't change or modify, it just adds to the other right to unpaid parental leave, for which is 18 weeks leave for parents who have children up to their 18th birthday, with a maximum of 4 weeks per year.
And Amy, in terms of, I guess, proof of any long-term medical concerns or anything like that, would it be the stock standard process in terms of getting something from a medical practitioner, or is there any parameters around the Act around what needs to be done?
Yeah, this is a really good question. At the moment, there isn't any, I don't think there's anything specified in the legislation about what evidence can be requested. And that's why I mentioned potentially creating a self-certification form. But this is going to be a really sensitive area. And I think it's worth noting that any conversations about this are going to have to be handled really sensitively, particularly because some employees are not going to want other people to know why they're taking time off. So definitely worth thinking about your approach there and what level of evidence you will require, and how those conversations are going to be handled. And it may be that the employees are completely comfortable with people knowing that they're taking carers leaves. Other people may not be. So that's just going to be an additional kind of layer of complexity, I guess, when you're implementing this, and that might be something to build into your policy.
Mm. No, that's definitely a fair point. And we do see it, you know, every time a piece of legislation is introduced of this nature, where it is quite sensitive, similar to, you know, family violence legislation, things like that. But it is about navigating with the employees that you have in your workplace, which the circumstances might be different to the next workplace. So it's like to what Amy said, it's all about making sure that you're kind of adapting and making it applicable to your workplace as well. So in terms of, I guess, changes that have come in, last year we heard a lot about when it comes to kind of paternity leave and changes that are coming up. I've been hearing that paternity leave has actually become a lot more flexible, Amy. How has the landscape changed here? And am I right in thinking it's a lot more flexible?
Well, you are and you aren't. I mean, all these changes that are happening this year have had lots of attention in the press, and actually paternity leave may be the exception in the sense that the changes are quite minor. So they apply from the 6th of April, as I've said, and they include the right to take the 2 weeks paternity leave in 2 separate blocks rather than at the same time. They extend the period within which the leave can be taken. So previously, as you I'm sure all know, it had to be taken within 8 weeks of the birth or adoption. It now has to be taken within 52 weeks. And then there are minor changes to the notice period required to be given when someone wants to take paternity leave. So really, in practical terms, I don't think these changes are going to have a huge impact. But again, it's more around housekeeping. Employers should review and make sure their paternity leave policies are up to date, that people managers are updated on the changes in these rights. And I guess it's also a good time for employers to revisit what level of payment they will be making for statutory paternity leave as a matter of policy. And certainly what we're seeing as practitioners is that offering full pay for those 2 weeks is definitely increasingly becoming the norm. One other thing I wanted to mention here, and I'll mention this a few times during the next half an hour or so, is that there are also potential changes that might come in if we get a change in the government. So Labour has indicated that it might scrap the 6-month service requirement that is required for someone to qualify for statutory paternity leave. So there may be further changes.
Oh, wow. Okay, so further changes on the horizon, but
Absolutely.
at least we've got a rough idea that it's you know, happening, and it's always good to have it on your radar as an employer as well. And in terms of, I guess, topical things and what we've kind of heard over the last year or so, flexible working, Amy, it has definitely become the talk amongst a lot of HR professionals, a lot of employers, and I believe that there have been some major changes that kind of require review from employers. So Amy, can you shed some light on how everyone can ensure their workplaces are compliant and up to speed? What do we need to know?
Yeah, so this is definitely one of the topics that has grabbed the headlines in the last few months. And obviously it's a really hot topic and has been since COVID, and practices for working practices have been changing. So yeah, from the 6th of April, we've got new measures being introduced to make it easier potentially for employees to reach agreement with their employers about flexible working patterns. So this new act will give employees, again, a day one right to make a flexible working request. At the moment, an employee needs 26 weeks service. That is going to drop so people can make requests from day one of their employment. The new act will also give employees the right to make 2 rather than 1 flexible working request in any 12-month period. So that's a shift as well. And interestingly, under the new law, employees won't be required to explain what effect the requested change would have on the employer, or provide any potential solutions for dealing with those effects. So that was something that was part of the requirements for a flexible working request previously. What has been introduced and what is new is a requirement on employers to actually consult with employees or the employee that has made the request in order to explore what the available options might be before deciding on the outcome of the request. And then finally, the other change is that employers must respond within 2 months of the change of the request, sorry, rather than 3. ACAS have also produced a new code of practice on handling requests for flexible working, which really emphasises the need for meaningful engagement and exploring alternatives jointly with the employee. Now, there is lots in this that's not changing, which I'll also highlight quickly. Employees still have to say that they're making a statutory flexible working request, which I think in practice a lot of employees don't, and employers probably turn a bit of a blind eye to. Employers are also still required to deal with applications in a reasonable manner. So that is judged partly on compliance with the ACAS code of practice. They can only be refused for 1 or more of 8 permitted business reasons, which are not changing. And employees can complain to an employment tribunal if they think the application has been rejected unfairly, or if it's not being dealt with in a reasonable manner. I think the key point here is that it is still a right to request flexible working. It is not a right to have flexible working. And really, employers can still turn down requests that they can't accommodate. The significant changes here, I think, in summary, are likely to be this shortened time frame for a decision and the new emphasis on consultation and compromise, which is really, and again, this is another, perhaps we'll put this in the follow-up to the webinar, but it's worth having a quick read of the new ACAS code on this. Because that really highlights the fact that employers must not reject a request without first consulting the employee. And it talks about if the original request cannot be accepted in full, and I'm reading directly from the code here, the employer and the employee should discuss if it may be possible to secure some of the benefits that the original request sought. They should discuss potential modifications of the original request or any alternative flexible working options that might be available and suitable for both sides. So this is really all about consultation. So as I said, the basic position isn't changing. It's still a right to request, not a right to, but there are shortened timeframes and more engagement required, I think, in summary, Sanam.
Okay, and so what I'm getting from this, like you said, is that, look, if a request comes in, we really genuinely have to consider it. We have to make sure that we're working with the employee to see if there are any avenues or partial components of that request that we can, side with or help out with and accept. But otherwise, if we cannot accommodate as a business, then we can put that case forward and say, look, this is why we're declining the request. So at least, like you said, there's some avenues for the employer there. It's not completely the worst case scenario. And so in terms of some other areas that have kind of changed as well, what we've seen is a change with redundancy protections. So some employers, I think that this is the hot button topic, actually. Move over flexible working. Redundancy is definitely something that people have been talking about. We've seen it in a lot of different jurisdictions and countries. And the employers are finding themselves in these tricky situations where they're looking at redundancies. But an even trickier situation could be that somebody is on maternity leave at the time, and they're now looking at going through a redundancy process. Amy, have you heard any changes around this particular area, what employers might need to look out for?
Yeah, absolutely. There's a significant change here, you're right, Sanam, and it again takes effect on the 6th of April, so it's something that we need to be mindful of now. It's not happening in the future. So from the 6th of April, employees on maternity, adoption or shared parental leave will benefit from additional protection against redundancy. So at the moment, if you are making or proposing to make an employee on maternity leave, adoption leave or shared parental leave redundant, you must offer these employees suitable alternative employment if it exists. You don't have to create a new role, but if there is a role that's suitable, those individuals would have to be offered that role in priority to anyone else who's provisionally selected for redundancy. And that protected period covered the period of the family leave. From the 6th of April, the protected period is going to be extended. So the right also applies during pregnancy and for an 18-month period after the birth or adoption. So in real terms, you could be talking about an individual with kind of 2 years worth of protection if you take into account the leave and the pregnancy. And yeah, as I say, so the protection starts as soon as the pregnant employee notifies their employer that they are pregnant, and it will end 18 months after the date of birth or placement for adoption. I think the thing to highlight again here is that the protection gives employees priority for redeployment opportunities, but it never was, and it still is not, a ban on making employees redundant during this protected period. So that's a really common misconception generally, that employees who are pregnant or on maternity leave or on shared parental leave cannot be made redundant at all. That is not the case. It's just that they have an enhanced level of protection, and this requirement on employees to carry out proper search for suitable alternative employment and to offer it to them in priority to other members of staff. I think in terms of the implications, I've put in this slide here, obviously, again, we're talking housekeeping, updating your policies, making sure your staff are aware of these changes. And then if you are, as an employer, planning an imminent restructuring, you need to ensure you've properly thought through the implications of these new protections and the issues that might arise. I think in practical terms, what we really might see is an increase in the number of employees with protection. So you've got new and expectant mothers with this kind of double the length of protection, and then obviously other employees as well, and you know, fathers taking shared parental leave. What we are probably going to see, certainly for larger employers, is that there are, in a redundancy situation, potentially multiple people with protection who have priority to those suitable alternative roles. And then there's going to have to be a further selection process to decide who in that priority status category actually gets the role. And there's no kind of guidance in the legislation around how to decide between these people. So it's probably going to come down to a normal, you know, redundancy selection criteria. But again, you know, it's a high risk area, because if you fail to offer a priority employee a suitable alternative role that does exist, they would have a claim for automatic unfair dismissal, which could mean compensation that's not capped. And it's also one of those claims that doesn't require 2 years service. So that's really, really important.
And I think definitely it's fair to kind of highlight what you've said a bit earlier, Amy, around, look, this is not the ideal situation. And sometimes it is a case of, look, this is a redundancy. It is a last resort for a lot of employers. And I would like to reiterate that employers should view it that way, in terms of making sure that they're not just kind of proceeding and moving ahead, especially in these scenarios where we are dealing with these, you know, protected characteristics and these areas where it can get very, very tricky and murky waters very quickly. So, so definitely be cautious to it. Definitely think about it before you go down that path. And sometimes just holding off or waiting is sometimes a better process. But of course, every business is different. So always see, you know, kind of what works for you. And in terms of, I guess, another change that's come up is around, of course, we always see wage increases or wage changes, and this year is like exactly like the others in terms of seeing a change with rates. But what we've also seen as well, Amy, is a big jump in unfair dismissal compensation. So what are these numbers that we need to look out for? And before you get into it, Amy, I just wanted to say that somebody has asked around whether we're going to get the recordings and the webinar presentation. Absolutely, you will get all of that. So please do not frantically write all these numbers down.
Absolutely. So, I mean, you may be aware that these numbers change every April. What we've seen this year, and probably as a result of the cost of living crisis, is a jump in quite a few of these. So particularly, just to highlight, as you can see in this table, at the bottom of the table, for the purposes of calculating statutory redundancy payments, The cap on a week's pay is increased £700. So that's a big change. Nice round number for people to remember. It's always, I find it really difficult each year to remember what the new figure is. But yeah, as you highlighted, Sanam, I think probably another one to really be mindful of is this increase in the cap on unfair dismissal compensation. What I do also want to add at this point, and coming back to something I said earlier, is that this is one of the areas that could have significant change if there's a change in government at the next general election. So Labour have made it clear that if they were to come into power, they would potentially remove that cap altogether. So there is no longer a cap on unfair dismissal compensation. So it would be like a discrimination or a whistleblowing claim where compensation's uncapped. And the other key change is that they're talking about removing the qualifying period of service for unfair dismissal claims altogether. And that would be huge. So at the moment, as you know, an employee needs 2 years service in order to bring an unfair dismissal claim, unless it's an automatically unfair dismissal claim, like what we spoke about a moment ago in redundancy during maternity leave. If they were to remove that period of qualifying service, that would be a huge shift in employment law, probably the biggest change for the last 40 years. So that's one to keep an eye on. But at the moment, yeah, as we can see, these rates are going up, and it's good to be mindful of those.
I mean, I was going to say that the fact that that is a potential, Amy, the fact that that kind of cap can be removed with the new government is a bit alarming, because I'm sure a lot of employers have hung their hat on that 2 years under 2 years service. So
absolutely. Yeah,
so
absolutely. And obviously a lot of employers, assuming that there's no contractual right to a disciplinary process or a performance improvement process, many employers, when faced with an employee that is underperforming or is perhaps even in a redundancy situation, and they have less than 2 years service, they will often move and terminate employment without a full process, because if there are no risk factors, like that person having a disability or having had a lot of time off work or whatever, if those risk factors aren't present, you can usually get away without having to go through any sort of a process, because they don't have an unfair dismissal claim. But if that cap or if that minimum service requirement, is going to be removed, which could happen if Labour come in, and obviously there'll be a runway for that to happen, that would be a massive change, and it would mean that employers have to apply the same rules to everyone regardless of length of service, which many would say is the right thing.
Yeah, no, absolutely. And definitely watch the space, everyone. I'm sure as this unfolds, we will be putting out more information, and definitely, like I said, Amy is there if you want to contact her and get in touch. Now, in terms of another interesting change, I've heard that the TUPE rules have changed in terms of small employers. What can we expect to see in this space, Amy? Is there anything for smaller businesses that they should know?
Yeah, absolutely. So this is a change that's coming into effect on the 1st of July, and it's really an extension in the limited circumstances where employers consult with employees directly if a 2P transfer is taking place. So just to step back slightly, where you have a 2P transfer, so you are required to inform and consult with the staff affected by the transfer. Currently, there's a requirement to elect employee representatives where appropriate representatives are not in place already, apart from if it's a micro business with fewer than 10 members of staff. But that kind of exception is being changed, so that actually it's going to be extended to 2 other situations if there are no employee representatives in place. So if the business has fewer than 50 members of staff, regardless of the size of the transfer, or if the transfer involves fewer than 10 members of staff, even if it's a huge business, you can do that consultation directly. So this makes total sense, and really the aim of the change is to streamline the 2P transfer process and to reduce the burden on small businesses.
Oh, which is perfect, because I feel like you said, smaller businesses, they always, the brunt or the weight of having to do these processes or to do anything like this always takes up a lot of resources because they just don't have the
Yeah,
resources.
absolutely, yeah, disproportionately so quite often.
Yes, yeah, no, absolutely right. So one of the interesting things, Amy, if I could say, that you kind of threw into the mix was around allocation of tips. And the tips can be a major part of running a hospitality business, right? So I've heard about these potential changes impacting an employer within the sector. What changes are we seeing here in this space?
Yeah, so the law here is changing on the 1st of October. So at the moment, employers are able to obviously apply a discretionary service charge to bills, and that service charge belongs to the employer until it's transferred to the employee in full or potentially with a deduction made. And typically, deductions that employers make, and we're thinking about the hospitality industry here, obviously, will cover certain costs like credit card charges or the cost of administering and paying the tips to employees. And very commonplace would be a deduction of kind of 3 to 5%. So the intention of the Employment Allocation of Tips Act 2023 is to prohibit that practice. So it prohibits businesses retaining all or part of tips paid rather than passing them on in full to staff. So under the new Act, all tips, all service charges and gratuities have to be paid to workers and cannot be subject to deductions, including of administration fees. They have to be paid to workers at the end of the month following the month that they were paid by the customer. And the tip distribution has to be fair and transparent. And the legislation it has, or there's a statutory code of practice, which is not yet final, but it's what will be worth reading once we do have it. That also says that employers have to have a specific written tips policy to include things like whether they encourage or require customers to pay tips, how they ensure that the tips are paid fairly and distributed. And then the employer also has to retain a tipping record of the total tips received and the details of their allocation to workers for up to 3 years. So these are some very new and quite significant changes here. Workers also have the right to request a copy of their tipping records in order to bring an employment tribunal claim if they believe that they're not receiving the tips they should be. And they will have up to 12 months to make a claim. So essentially, every business with employees or agency workers who receive tips will be affected by these changes. So potentially, people have estimated up to 2 million workers in the hospitality industry. Yeah, so I think that will be a significant change. And as I say, we're waiting for the final code of practice, which will definitely be worth a read.
It's quite interesting. I mean, just for context, I've worked as an advisor effectively for employers in the hospitality sector, and this is always something that comes up, regularly, because you wonder how tips are allocated and how they're going to be distributed out, and a lot of employees are usually unhappy with how that goes. So it's interesting to see this being very clearly laid out now and setting parameters on how tips will be handled, and the fact that you can't deduct or move tips around in a particular way where sometimes it would get spread out amongst all of the staff or some retained by the employer or by the business. So definitely a huge change, I believe, for the hospitality sector, Amy, and fair call to point it out. 2 million employees or businesses, you said that's a large number. So yeah,
absolutely. But again, that's not till October, so there's time to review the law, take advice if you need to, and get things in place to make sure you're compliant by then.
Yes, and definitely read the guidance when it comes out as well. It will set out really good parameters and kind of, I know with the guidance that usually comes out even by ACAS, very, very well done in terms of
it's always very simply drafted and gives really useful explanations and examples.
Yeah, no, absolutely. So definitely tap into that resource, for everyone out there that's kind of listening, well worth it. And there's been one area that I have seen time and time again coming up in almost every jurisdiction. New Zealand's talking about it, Australia's talking about it, and I can see the UK is now moving in this direction as well, which is the duty to prevent sexual harassment. I understand we're seeing changes later on in the year in October. Amy, what's going on here? What do employers need to watch out for?
Yeah, so I mean, this is arguably one of the most important changes to discrimination laws in recent years. Let's just step back a moment and remind ourselves of what is sexual harassment. So in the legislation, sexual harassment occurs when a person engages in unwanted conduct of a sexual nature that has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that person. Now, from the 25th of October, the Equality Act, where just read from, will be amended so that employers will be subject to a new, completely new duty to take reasonable steps to prevent sexual harassment of their employees in the course of employment. So effectively, employers will have a new proactive duty to prevent sexual harassment in the workplace and a greater responsibility to make workplaces safe for staff. So the law already provides a defence to a harassment claim if the employer can show that they had taken all reasonable steps to prevent it from happening. So this meant that it was advisable to take steps, but there was no actual requirement to do so. But contrast that to the position after October, which is we've got the law going further and placing a separate legal obligation on all employers to take proactive measures to prevent sexual harassment. So if an employer does not comply with this duty, and if an employee brings a claim in an employment tribunal for sexual harassment, then a claim in relation to a breach of this duty will be likely attached to that claim. So it's not a freestanding claim. And if the employee is successful, there could be an uplift in their compensation by up to 25%. And in addition to that employment tribunal enforcement, there's potential enforcement as well by the Equality and Human Rights Commission. So this is a big change. Again, the legislation will be supplemented by a new statutory code of practice, which is being produced. So we're going to see this sometime between now and October. I would hope close to now than October, but you never know. And what's not particularly helpful at the moment is that we don't actually have any guidance on what taking reasonable steps means. So it's quite hard to, until that guidance comes out, to kind of make sure that we're doing the things that we need to be doing. But at a minimum, I think in terms of preparing, we should be creating or updating central reporting registers for complaints about all forms of harassment, not just sexual harassment. This only applies to sexual harassment, but anyway. We should be updating and recirculating our anti-harassment and speak up or whistleblowing policies and thinking about how they're implemented in practice. And these policies shouldn't just be, paper where prohibited behaviours are listed, but they should explain the individual responsibilities of all staff in eradicating harassment from the working environment. Training is always important, and I think up-to-date training, tailored training is going to be a key feature of what taking reasonable steps means. And that will give those who witness harassment, the bystanders, the means to intervene and support the victims. Training that is simply a tick box exercise, or which is stale and hasn't been refreshed, is unlikely, I think, to be seen as a reasonable step towards preventing a harassment. I think one other really important area to think about is targeted risk assessment. So really looking to identify the risk factors and what action can be taken to mitigate those. So it's almost like treating sexual harassment like you would any other kind of physical or mental health and safety risk, and doing that kind of risk assessment. And I think finally, it will be important to consider what steps can be taken to prevent third-party harassment, so harassment by customers and suppliers and so on.
Yeah, and I think it's a fair point to call out that there are to basically treat this exactly like you would with any other health and safety issue in the workplace. It's the simplest way to kind of boil it down to how to address it. A lot of times when you think about it and you're wondering how to eliminate it or prevent it, you're looking at it as, you know, this is this big mountain that I've kind of got to tackle. But it's a lot easier to kind of simplify it and bring it down to that and then work through that. And two areas that I normally see employers kind of getting it wrong when we see these cases come up is one, that they don't actually have a policy in place that can really show the path or the avenue where the employee can actually raise their complaint and
Exactly.
that responsibilities. And then also the second one that I see come up quite often is that if there is anything going on in the workplace, like what Amy said, it's not about doing a policy and leaving it in a locked cupboard. It's about making sure that it's living, breathing. It's a health and safety risk. So it's about making sure registers are updated and that you're mitigating any of the risks and eliminating them if you can when it's third party customers, because we see it a lot when we're looking at hospitality and other areas, bars, you know, and pubs. Things always happen in those scenarios. So it's about how you can work with the law on making things safe for the employee.
Yeah, absolutely. And just one final point, Sanam, I think when we're thinking about reporting complaints and having, you know, policies and clear avenues for reporting complaints, in tandem with that, as employers, we also need to be thinking about how we will investigate complaints, how we will ensure they're dealt with effectively. And that, I think, can be a part that's often doesn't get as much attention as, you know, making sure people know where to report, what as we as an organisation are going to do if a complaint is raised to ensure it's not swept under the carpet and that person is, you know, exited under a settlement agreement or whatever. You know, that happens time and time again, but it doesn't change this law is really important.
No, you're absolutely right. So I think definitely really key and important things to walk away with. You have, you know, until October to kind of start thinking about this and looking at revising things. And like what Amy said, look, we don't exactly have the reasonable step guidance yet, but I'm sure that will slowly be released as the law kind of unfolds and we have to start seeing adoption of the new legislation. So the last thing that we're going to cover before we get into the Q&A component, I can see the questions coming in and it's great to see everyone in the chat. So good morning, everyone. I can see you going back and forth. Is the what's kind of on the horizon and what's happening maybe later on this year and then also looking into next year?
Yeah, so there are quite a few changes on the horizon. And as I said, some of these we know about already. We know it's going to happen. It's just the date's unknown. Some of them we are expecting if there's a change in government, which, you know, is looking increasingly likely, I think. On the horizon, firstly, sometime in the autumn, we don't know when, we're predicting September, it might get pushed back. There's going to be a new right for workers to request a more predictable working pattern. So this act has been passed, but it's unclear when it will come into force. It's likely to have the biggest impact in industries where shift patterns are, you know, the norm, where rotas vary and where work is very casual. But it's not entirely clear because we don't have detail yet how it's going to work. But employers are going to need to put in place procedures to ensure they deal with any request reasonably and within the required timescale, which we understand is 1 month. So that's something to just keep an eye on because it's going to be, I think we'll hear more about that over the summer probably. Secondly, we've got a new right to neonatal leave, which is going to come into effect in April 2025. This is a completely new entitlement to leave and pay for parents of babies who are admitted to hospital within 28 days of birth for 7 days or more. And as you can see from the slide, it is a day one right, and there are some qualifying requirements as in all of these types of leave. And there is a requirement on when the leave has to be taken. But this is, again, something that will probably require updates to your staff handbook to ensure that employees are aware and line managers are aware of this additional right. If you want to go to the next step, brilliant, thank you, Sanam. The next potential change is also a really big one. The law on post-termination restrictive covenants, which prohibits employees from doing certain things like working for a competitor or poaching customers for a certain period of time after their employment ends, is set to change. So at the moment, Non-competes, which say an employee can't join a competitor for X number of months after they leave, are potentially enforceable of up to 12 months, for up to 12 months in length, but depending on the seniority and the role in question. So, you know, for someone junior, 12 months is not going to be enforceable, but for kind of board level appointments, potentially. However, this is set to change. So there is a proposal at the moment for regulating non-compete clauses in employment contracts, following a consultation by the government in 2020, which would mean that these non-compete clauses are limited in length to 3 months. So that would be huge. That would be a huge change. You might have heard that just last week, the US has introduced a blanket ban on non-competes. So that was a huge news to me. And it shows that this is the direction employment law is going. And I think that move is probably going to put more pressure on our government to push forward with this proposal. At the moment, they're saying that they will legislate when parliamentary time allows. That's their exact wording. Obviously, we don't know when parliamentary time allows. But that is something to bear in mind, I think, for employers who might decide that they want to get ahead of the legislation and ensure that all of their new contracts contain non-competes that are 3 months in length maximum, so that you don't have to then amend contracts when the law changes. But that will be something that, you know, employers will need to consider over the next few months. And then in addition, we have got the possibility of a new statutory code of practice on fire and rehire, which came out of the P&O ferries controversy in 2022, where they dismissed 800 staff without consultation. That was back in the news again just this morning. This code of practice is yet to be approved by Parliament, so at the moment it's a kind of wait and see, but just one to remember. And what it might mean is that there are much stricter requirements on dismissing and re-engaging people in order to change terms and conditions. There's also a consultation currently open on reintroducing employment tribunal fees. So a new fee of £55 is proposed. I won't say any more about that because we're running out of time, I know. And then finally, just to touch on what might happen if Labour win the next general election. Unfair dismissal becoming a day one right, potentially removing the limits on unfair dismissal compensation, potentially extending the right not to be unfairly dismissed to workers as well as employees, and potentially extending the time limits to bring employment tribunal claims. So if that happened, I would say that would be the most significant change in employment law in 40 years. And as practitioners, we'll be very busy, and HR teams are going to be exceptionally busy if that happens. Yeah, that's everything I had to say about things that are on the horizon.
As you rattled that off, Amy, I was starting to get sweaty palms, I'm not going to lie. It seems like interesting changes, but also very difficult ones for an employer to navigate. And you're absolutely right. It's going to be a lot for you know, HR professionals, as well as lots of employment lawyers that are going to have to be tackling these, and it'll be a while employers, I'm guessing, are trying to navigate as the new laws come out, or if the government actually changes. So there has been a lot of questions coming through. So this isn't the end. Don't worry. I've checked in, and our team has said that we can extend it out for a little bit. So if everyone has time, Amy, specifically you, because I can't hear what everyone is saying. But if you have a little bit of time, we'll go through some of the questions now. We've definitely had a lot come through, so we won't be able to get to everything, but as much as we can, will be great. So I'll kick things off. One of the questions that came in quite early on was around the irregular workers. So this person is saying that they have actually rolled up the holiday pay at that 12.07%, and they understand that it is that legally this is compliant from the start of the next holiday year that the employee will be doing. So what would be the risk to an employer of using this process before the next holiday year? So if they were to kickstart and bring this into place now, they have a small amount of irregular workers, so that's why they're asking.
So I think the theoretical risk is a claim relating to breach of the working time regulations, but definitely a theoretical risk. It may be that the employees are, you know, comfortable with what you've put in place already. obviously depending on whether they've consented to it. And I mean, it's difficult for me to be too specific here because I'd need to really know the factual background here and how this change has been implemented, because we're talking potentially about a change in terms and conditions. Definitely a risk, probably only going to arise if there's a dispute about something else, I would imagine. But I'm happy to speak offline about it.
Perfect. So I will, like I said, Amy's details are there, and then we will be sending out kind of information as well after the presentation and the webinar. So in terms of a category of carers leave, I believe we got a few questions around that, but what I'll actually do, Amy, if that's okay, I might move on to something that's around the holidays. So when we spoke about those irregular hours and in relation to holidays, somebody did bring up, I thought this was interesting. We had a couple of questions around this. Contractors that work on an ad hoc basis. Would this apply to them? The 12 point. Okay, perfect.
No. So this would not apply to contractors as long as they are definitely contractors. And I say that because obviously what you have on paper isn't necessarily what an employment tribunal or HMRC would say is the employment status of that person in question. So that it just makes it all the more important that your contractor agreement, your consultancy agreement, whatever you want to call it, has the necessary protections in place to ensure that these individuals are not later going to complain that they were entitled to holiday pay. And again, we can, again, offline, very happy to take a look at what you're using at the moment and make sure it's fit for purpose, up to date, and it's going to protect you in light of these changes.
Perfect. And in terms of the protected period, this was something that came up quite a bit. And I believe you addressed it, but just to confirm, does a protected period also apply to men just as much as women, or is there any particular categories? How does it work?
Yeah, so it also applies to people taking shared parental leave, interestingly, not paternity leave. So what the protection would apply from the beginning of the shared parental leave to either the end of the shared parental leave period if the person is taking less than 6 weeks shared parental leave. But if they're taking more than 6 consecutive weeks shared parental leave, the protection actually lasts for that full 18-month period from the child's date of birth. So that is quite surprising in the sense that a parent only needs to take a minimum of 6 weeks consecutive shared parental leave before becoming eligible for 18 months of protection, and contrast the position to the absence of protection for employees taking paternity leave. So we do have a bit of a disjoint here in what the protection is, depending on the type of the leave that's taken and also how long people have taken leave for. So again, happy to speak offline if you've got specific scenarios that you want to plan for.
And in terms of the flexible working, one of the things that came up, and I think after listening, correct me if I'm wrong, I think I've got the right answer to this one. Somebody asked that if the business is happy to accept the flexible working request, is there still a requirement to consult? And I would say no in this case, but hopefully I've got the right answer. Is it a no?
Absolutely, yeah. If you're going to accept the request basically without modification, then you could do that immediately without the need to consult, yes.
Oh, brilliant. Okay, so that's good. So that at least, you know, allows for less process if you are going to go through and accept. And one of the things that somebody mentioned was around the neonatal leave that you had brought up. And they asked around, would the payment of the leave, if requested, be paid alongside the maternity or paternity leave, kind of like a dual statutory payment?
Yes, it's additional to the other types of family leave. But in terms of the pay, obviously there'll be the statutory pay, but depending on whether employers decide to enhance it or not, like maternity leave or any other form of leave.
Okay. And is there a limit in relation to how long leave must be taken, or is there any set period or anything like that?
For the neonatal leave,
Mm.
yes, and now I think it was back on the slide actually. If you flick back to the neonatal leave slide, think I put it there, but I can't remember offhand. It's the first.
Yes, there we go. Up to 12 weeks.
Yeah,
Okay.
yeah. Oh, that's not right. 68 weeks of the baby's birth. I'm going to double check that actually and come back to you if that's okay.
All right, no, perfect. I've got that one on the list as well. And somebody asked if the neonatal leave also applies to partners, as in, maternity and adoption.
Yes, absolutely. So as we say, it's for both parents.
Perfect. And it seems that there's been some questions around tips. Now, this might be veering off of tax advice, but the question is whether these tips are taxable for these employees.
They would be subject to income tax, but not national insurance contributions. But again, probably a question for your accountants rather than for me.
I did think that every time I get anything severely payroll related or severely related to tax, not my area. So I've got one question here that says, what actions an employer can take when one of their employees joins a competitor. I just wanted to say with this one, I think it'll probably be better if we take it offline. So whoever's asked that question, definitely I'll get Amy to kind of reach out and see where
Yeah.
And
I should just add there, Sanam, that if anyone wants to have a quick chat after the webinar, I would be happy to do, free introductory calls with people to talk about high level issues. But I mean, on that, it's going to come down to what the contract says largely. So yes, there might be a non-compete in the employment contract. If there's not, then you're going to have to rely on the duties of confidentiality in the employment contract. And it may be that you can't prevent them joining a competitor, but you can certainly send them a very stern warning about not using your confidential information in the future.
Yep. Oh, perfect. And I'm glad that you mentioned that about doing kind of a free introductory call. We've had these questions come up earlier on in the webinar. So it'll be great for people to know that, yes, you can reach out to Amy, free introductory call, and then you can kind of at least get an idea of where things are headed and what you might need to have a look at, and then kind of take it from there. And in terms of, I guess, one last question before we wrap it up. I'm just trying to go through and see what we've got.
I saw one come up about how much carers leave, the notice in order to take carers leave, which is a really good question. And actually, it varies according to how long carers leave the person wants to take. So I can put this in the FAQs, but it's not a fixed period. It depends on how much leave you're taking, basically.
Oh, perfect. Okay. Well, I think what we'll do is we'll probably wrap this up. I know that there's still a lot of you on the call, so definitely please keep an eye out for our FAQs. Amy, it has been amazing having you here. Absolute wealth of knowledge. I told you. See, when I promise, I always try to deliver. But we are very excited to have you, and thank you so much. And for everyone, I hope you're having a lovely morning. A survey will pop up automatically after we finish the webinar. Please participate. I always ask because it will teach us what we need to do better for next time, and also where we might be doing okay, and then it could, inflate our egos a little bit along the way. And in terms of kind of all of these additional resources and everything, we will be sending that out after the webinar. So keep an eye out for that with the recording and all of the information. So for everyone that's asked whether you get the recording and the slides, absolutely, we'll be sending it out shortly. And I guess that's it for me, Amy. Thank you so much. It has been amazing, and we really appreciate all of this knowledge.
You're very welcome. Hopefully speak to some of you in the future, and I'll be back for hopefully more webinars if you like this one.
No, definitely. Absolutely. And everyone enjoy the sunshine. I've heard it's really good weather. So have a lovely day, everyone. Thank you so much for joining us.
Thanks, guys. Bye.